I call this meeting to order and start with the acknowledgement, of course, that when we are in Ottawa, we meet on the traditional unceded territory of the Algonquin people. Pursuant to Standing Order 1082 and the motion adopted on April 29th, 2021, the committee continues its study of enforcement on First Nations reserves. To ensure an orderly meeting, those of you online now speak and listen in the official language of your choice, but choose at the bottom center of your screen the globe icon on which you can select floor, English, or French. And whatever you select, you can actually change from English to French without further technical change. When speaking, ensure your video is turned on, and please speak slowly and clearly. When you're not speaking, your microphone should be on mute. And pursuant to the motion adopted on March 9th, 2021, I must inform the committee that all witnesses have completed a technical pretest. And so we're awaiting Chief Matthias of the Long Point First Nation, but we do have with us Chief of Police Roland Morrison and Julian Falconer, partners at Falconer LLP, both on behalf of the Nishnawbe Police Service. So Mr. Morrison, Mr. Falconer, we're going to start with a 6-minute presentation followed by questions. Please go ahead.
Good evening, I guess, committee members. My name is Roland Morrison. I'm the Chief of Police for Nishnawbe Police Service. Nishnawbe Police is the largest Indigenous police service here in Canada. We have over 220 officers, and with civilian staff, we have nearly 300 employees. We are responsible for policing 34 communities within the Nishnawbe Nation territory, which is situated in Northern Ontario. Of the 34 communities, 23 are remote fly-in and 11 are road access. However, some of our road access communities I would probably deem as remote because they are in remote locations. So NAPS is also a member of the First Nation Chiefs of Police Association, and we are also an IPCO member, which is the Indigenous Police Chiefs of Ontario. We are a self-administered police service, and we are signatory to a tripartite agreement with the federal and provincial governments under the First Nation Policing Program. So I want to thank everyone for the opportunity to speak here today. I'm sure, if this opportunity went out to the other chiefs, they'd be more than welcome and very happy to be here before you, especially to talk about the enforcement on First Nation reserves. So I'm aware that there are various justice programming on First Nation communities across our country, from Tsuut'ina in Alberta to Kahnawake in Quebec to Akwesasne in Ontario, and also most recently in the Treaty 3 area in Northwestern Ontario. I don't know particular details on the programming for these communities. However, what I can speak to you about is what's happening or what is occurring in the Nishnawbe Nation area. So what we do for enforcement in our communities is basically criminal code enforcement. Many of our First Nations have enacted banned bylaws. However, those bylaws are not prosecuted anymore. Early in the early 2000s, Ministry Attorney General stopped prosecuting the banned bylaws. So the communities have been pressing MAG to get their bylaws heard. However, there's been a lot of reluctance from MAG to do this. So in some of our communities, some of our mostly road access communities, a few communities have adopted provisions from various provincial acts, such as the Highway Traffic Act, Liquor License Act. It allows us to perform enforcement, and prosecution of that rests with the Ontario Provincial Offences Court systems. So, and many of our communities don't have, especially in the remote north, don't have access to the provincial offences systems. So as I mentioned earlier, NAPS falls under the First Nation Policing Program, which is an outdated program. The terms and conditions that govern the First Nation program are very restrictive in what is eligible expenses. For example, right now, crime units, emergency response, and victim services are deemed ineligible. So under current Police Services Act and the forthcoming Community Policing and Safety Act, Law enforcement, emergency response, and victim services are all core functions for a police service. Yet under the First Nation policing program, funding for these aspects of core police functions are not allowed. For example, within our police service here, we have a program called the Survivor Assistance Support Program. This SAS program, which we call it, is designed to support the immediate needs of victims of intimate partner abuse and sexual abuse. So when you look at the recommendations from recent inquiries, such as the MMIWG, to which the federal government, has recognized, why is it that Indigenous police services, such as NAPS, we have to apply for funding for core policing functions? So when you look at the FNPP, this is why the FNPP needs to be updated. So without the proper funding to meet core functions in policing, and with no avenue of prosecution of First Nation community enacted laws, we had to be creative, especially when it came to COVID enforcement. Because COVID enforcement in Ontario, here, and as everyone is aware, use the existing provincial offenses systems. And as I stated, many remote communities that we police, there is no system for enforcement. So like I said, we had to be creative. And this is where we asked our legal counsel, Faulkner's LLP, to come up with what we feel is something that our communities can use for COVID enforcement. So I am going to have our legal counsel explain exactly what we did. Okay. So I'll turn it over to you there, Julia.
Thank you, Chief. And I have the honor of not only speaking to you from HQ at the Anishinaabe Police Service in Thunder Bay, but I want to acknowledge that I do so in the traditional territory of Fort William First Nation, a treaty partner of the Robinson-Huron Treaty. And I want to simply acknowledge how fortunate and honored we are as a law firm to act for Anishinaabe Police Service. I have been party to commentary by many from Canada, many from, when I say Canada, the Canadian federal government, many from the provincial government of Ontario, all tripartite partners with NAPS. And they, as we work our way through difficult negotiations, routinely observe about NAPS's very credible standing as a police service. In fact, one of the top Indigenous police services, if not police services in this country. That having been said, we sent some materials that would have been distributed to each committee member in the last 20 minutes. There should have been 3 attachments. And if I could simply ask you to open up one of the PDFs, there were 3 PDFs. One of them is a PowerPoint. If I could ask you to open that up, there's just a few slides, and uncharacteristic of a lawyer, I'm going to try not to inundate you with materials, but I think I can whip through these slides and make the point that Chief Morrison asked me to make pretty quickly. Do folks have access to their email, and in particular, the PowerPoint one? It's a PDF that my associate Shelby Percival would have sent you all. Is that something people have access to?
I don't have it.
Oh, no.
System didn't work.
We're at the time past of the actual presentation itself.
Okay, so I'll go quickly then.
Yeah, please go. Yeah.
Yep. So first of all, when it comes to the template BCRs, I just want to emphasize what Chief Morrison is referring to. In fact, the traditional message to First Nations about how they are to protect their communities, and in particular control the flow of people coming into their communities, has been routinely the subject of a claim that you have to use the Indian Act. You will have heard repeatedly how inefficient and difficult that process has been. Chief Morrison reached out to communities, keeping in mind there are 34 First Nation communities under the NAPS jurisdiction, and reached out to community leaders. And really what in my view, is a perfect example of true community policing, engaged with the political chiefs and used their inherent sovereignty to help them, and so offered legal support to create what we call template band council resolutions. And these template resolutions, which are attached in the materials we provided you, assert inherent authority to protect pre-contact inherent sovereign authority to protect the safety of community members in the context of pandemic. It was our legal opinion that the assertion of that inherent authority is well-founded based on literally pre-contact laws, and more importantly, based on the recognition of the courts of the role of the community in protecting its membership. At the same time, these same BCRs, band council resolutions, adopted the provincial laws for Ontario around Emergency Management Civil Protection Act regulations and the Trespass to Property Act. They adopted them so that the police service, in addition to the assertion of sovereignty, so there would be respect for the sovereignty, would have tools through the Trespass to Property Act, the law of general application, and the Emergency Management Civil Protection Act, would have a way forward to prosecute, to lay charges. The Attorney General for Ontario, in written correspondence, has committed to pursue those matters. These template BCRs, is what we refer to them, were all created so that each community could simply add the list of exceptions to their closure rules and the list of exceptions to their regulatory requirements under COVID. But while they would be making the BCR their own, they were in template format so that each community would have a user-friendly way to engage with the police service, and the police service would have a reliable means by which to enforce the community's laws. These template BCRs have not only found places in INAN territory, Anishinaabe Nation territory, that NAPS polices. They're being used in Treaty 3 territory. They're being used on Manitoulin Island. They're being used as far south as Kettle and Stony Point, I'm pleased to observe. The bottom line is they found a way to disabuse themselves of the Indian Act. I want to move on, though.
We're going to run out of time for the question round.
So I'll take 30 seconds to complete it. I want to move on to a last point. You will repeatedly hear in the context of submissions made around Indigenous policing, how limiting the First Nations policing program is, what they refer to as FNPP. I just want to make an observation as a lawyer that acts for NAPS, for Treaty 3, for the Indigenous Police Chiefs of Ontario. Something really squirrely is going on. There is these terms and conditions that people find very limiting, naturally, because they are. As an example, they prohibit the usage of a lawyer to receive advice about funding agreements. But there's never a reference to the 1996 document, which is the First Nations Policing Program policy. It is an actual visionary policy created in the 90s that disappeared. The policy is still in effect, the FNPP policy, but you never hear about it. We call it the phantom policy. It has wide-ranging expectations that First Nations will enjoy an equitable level of policing as everybody else. But instead, all you hear about are these very limiting terms and conditions. I believe a bit of a shell game has been played with what I call this phantom policy. It's important that you get access to this 1996 policy that public safety literally never displays or tells people about. Take a look at it. It has everything you need to create equitable policing. Sadly, the terms and conditions undermine that policy. How odd. The terms and conditions used by Canada, used by public safety, are inconsistent with the policy that is supposed to be behind the program. This needs to be recognized and addressed, and I thank you for the time you've given me.
Yeah, and I'm sorry to stop that, but in view of the limited time, we do need to get to our committee questions.
Thank you.
And I need to ask Mr. Schmale, who will start for the Conservative group. Are you up first, Jamie, or Mr. Vidal? I didn't get the list.
Eric, then myself.
Eric Melillo, please go ahead, and you'll be up later. Eric, go ahead.
Thank you, Mr. Chair, and I just want to say I'm joining today from Kenora in Treaty 3 territory, but of course my riding extends right up to Hudson Bay and encompasses much of the territory that you operate in. as well. So I'm very appreciative to have the opportunity to have a conversation with both of you today. Chief Morrison, I'll direct my questions towards you, but if Mr. Faulkner wants to jump in at any point, please don't be shy to do so. I think I'll maybe go back to Chief Morrison. You mentioned I think the quote or the expression used was the outdated program that you're operating within, and I'm hoping you can touch a bit more on that and maybe provide some more thoughts. I've already heard some good testimony, but if you could provide some more thoughts on how the programs should be updated, how the agreement itself could change to improve the resources that you're offered.
Yeah, thank you very much for your question. Again, good to see members from Northwestern Ontario here. I think we also see Dr. Pulowski. Good to see you as well. So, Eric, I think when we look at the First Nation policing program, it is so restrictive in what policing can do. We can't provide, we have service gap deliveries. You heard me mention victim support. We have high rates of domestic violence occurring in our communities, but yet we have to apply for funding to run a program to support victims. When you look at crime units, we look at our crime severity index for Indigenous policing. Many Indigenous policing are very high on this index. And yet we can't have crime units to investigate major crimes. You look at emergency response, how many emergency response incidents occur, like missing people, when they're out on the land, harvesting. We can't have a program to go and search for them. We have to bring in all these services. We have to bring in our policing partners, such as the OPP, to conduct these services on our behalf. So those are just a couple of the aspects when I say that the First Nation policing program needs to be updated. When you look at a police service as this Anishinaabe Police and over 200 members, frontline police officers, and you think about another, like we are almost the size of Thunder Bay Police. Actually, we're very similar in size, but yet Thunder Bay Police has victim support, they have emergency response, they have court sections, which I'm going to say we have as well. However, they have more court sections, more court programming. When you look at the size of our service and you compare us to Thunder Bay Police, there is a lot of disparity there. We should have the same services as our counterpart just on Balmoral Street, but we don't have it. So when I say the First Nation policing program is outdated, we should be able to have these services within our police service delivery, but yet we don't because of the terms and conditions from the First Nation policing program. Again, like you heard from our legal counsel, it is very restrictive.
If I could just ask again, do you feel that there's sort of still an opportunity to work within the framework and the system that has been created, or would you suggest working towards a new arrangement?
Well, with the federal announcement, with the federal government's announcement to make First Nation policing an essential service, all the chiefs of police welcome this. Mm-hmm. But to be honest, I'm not holding my breath for it. I'm not. It's going to take some time to get this legislation in place. With the consultation that has to occur, it's going to take time to update this program. It is. We welcome the money that's been announced for First Nation policing program. However, when you look at the money that's been announced, and there's a lot of it, there's a lot there. We still have to apply for this funding. Why are we applying for core function policing when it should already be available in our agreements? That's what's hindering our services. The restrictiveness of the terms and conditions is restricting us. If we were to offload all these programs or what we're doing onto the OPP, they would probably be able to get this money because of their access to dollars. But for us, we have to write proposals, business cases, apply for funding, and do we get it? Sometimes we do, and sometimes we don't. So we have not only do we have our own funding agreement, we have several bilateral agreements. And I have to give praise to my finance department to keep track of all the reporting requirements for all these bilateral agreements that we have, just to ensure that we can provide a service to our communities.
Thanks very much. That pretty well does the 6 minutes. And so our next committee member is Pam DeMoff. Please go ahead.
Sorry, Chair, I didn't realize I was up just yet.
I'm sorry,
I
that's what I have on my list.
Supposed to be me.
Okay,
well, I'm ready to go.
Fine, go ahead, Lenore.
Sorry, but yeah, thanks. Yeah, Mr. Falconer, what you proposed was very interesting regarding the First Nations policing program, a policy of 1996. Could you actually explain to us how the mandate letters for the Minister of Public Safety and Emergency Preparedness and the Minister of Indigenous Services Canada, they have referred to co-developing a legislative framework that recognizes First Nations policing as an essential service, as was already said. Now, many of the calls for justice, from Reclaiming Power in Place, the final report of the National Inquiry into Missing and Murdered Indigenous Women and Girls, relates to justice and policing, and specifically the call for justice 5.4 states, we call upon all governments to immediately and dramatically transform Indigenous policing from its current state as a mere delegation to an exercise in self-governance and self-determination over policing. To do this, the federal government's First Nations policing program must be replaced with a new legislative and funding framework consistent with international and domestic policing best practices and standards, and must be developed by the federal, provincial, and territorial governments in partnership with Indigenous peoples. Could this new legislative framework work? And what do we need in order to address the issue of missing and murdered Indigenous women and girls in a sustainable way?
Well, thank you for the very insightful question. I would say that all of those recommendations are essential, and to respect and recognize the reality of women and girls and Indigenous victims, honestly, in general, being treated as less than worthy victims, is part of the reality of colonialism and racism. And the truth of the matter is, there's a long journey ahead of us. Let me be a practical lawyer for a minute. You have a policy that says the following. This is what the 1996 policy that you can't find on public safety's website. Okay, you can't find it in any of their literature. I'm told, I know it's still in force, but it's disappeared. This is what the policy says. It says, quote.
Where did you find it, Mr. Falconer?
I found it buried in the 2014 Auditor General's report. It was very interesting because here's the quote from the Auditor General's report in 2014. Quote, this is for the record, chapter 5, section 5.28 of the report. Quote, according to Public Safety Canada, the principles of the 1996 First Nations policing policy are outdated and impractical. And the First Nations policing program has evolved since these principles were endorsed. The department plans to update the principles of the policy and incorporate them in the program's terms and conditions. Okay, so this calls black white and calls white black, because the terms and conditions are not in any way an evolution. They actually are a means by which they keep First Nations down. Let me read you from the policy, 1996 policy, quote, First Nations communities should have access to policing services which are responsive to their particular policing needs and which are equal in quality and level of service to policing services found in communities with similar conditions in the region. First Nations communities should have input in determining the level and quality of the police services they are provided. And in addition, and Ms. Zan, I appreciate your question, but MP Zan, but I would say, yes, I want to see all of that happen, but you actually have an existing policy that they're hiding. And they replaced it with the terms and conditions. And the most disturbing, and March 11th, Grand Chief Fiddler, Chair, the Grand Chief of Anishinaabe Nation, and Chair Metatawabin, the Chair of NAPS, wrote a letter to Minister Blair, a letter that has yet to be acknowledged, a March 11th letter 2 months ago, citing the phantom policy, saying what happened to it, and then citing the terms and conditions. And this is the last part I need you to know about these terms and conditions. They prohibit First Nations from accessing legal counsel to either interpret their funding agreements, to give them legal advice in respect of disputes around the funding agreements, or to get legal advice around negotiating their funding agreements. That is reminiscent of the Indian Act prohibition on accessing lawyers. And all of that is in a letter of March 11th to the minister. All of that is in the terms and conditions. None of it is consistent with the existing policy, but they buried the policy. It's a shell game. I'm sorry to sound so dramatic. I call it the phantom policy. What they did, I'm assuming, is they realized they couldn't afford to do what the policy provides, so they made it disappear. And so I ask you, as a committee, find the phantom policy and make them just adhere to their own policy today. Yes, we should do all the things we're talking about, but my God, you have what you need. Sorry for the speech.
No, thank you very much. It's very informative. Does this older policy, though, also mention things like the two-spirited, lesbian, gay, bisexual, transgender, queer, questioning, intersex, and asexual people, and how we can help protect them, or how they can be protected also?
No, but here's the but. It mentions specifically legislated services at the same level of equity as the rest of the country. So now take that requirement of equity, transpose it to 2021, and presto, the very issues you identify could be done. I'm not saying it's the answer. I'm saying telling the truth is to tell police leadership. And by the way, AFN just had a conference, right, on policing. Everybody knows that. The phantom policy wasn't mentioned once because nobody knows about it. It's a trick. And I'm sorry to sound so dramatic, but it's really quite extraordinary. I'm sorry, but you're quite right. There are so many things that are missing. As a human rights lawyer, what you're saying is music to my ears.
Yes, and times have progressed, haven't they?
That's
so
right. Yes, they have.
Deal
that's
with
right.
these systemic racism and poverty and abuses that are intergenerational, and that we need to put a stop to and try and make equality right across the boards.
Yeah, and
Fantastic.
Lenore, I apologize for my intervention. I felt it was helpful to the analysts to be able to access that.
I
So our
appreciate it.
materials include the policy. We are sending you, Mr. Chair, a full package. The letter to Minister Blair attaches the policy, attaches the terms and conditions. We've attached a full package for this committee's consideration, and all at Chief Morrison's instruction. I just want to say he's quite a chief of police.
Okay.
We will make sure it gets there. Thank you so much. I'm
Thank
sure
you.
my time is up, but thank you very much.
Thanks, Ms. Sam. Madam Beyroube, 6 minutes.
Merci, Monsieur le Président. Je représente le territoire.
Thank you, Chair. I represent the Cree Anishinaabe territory of Northern Quebec. My question will be for the Chief of Police. Now, we were talking about systemic racism in the policing, and that leads to a lot of distrust. And in terms of the overrepresentation of Indigenous people in incarceration. How do you see this in your communities?
Good. Thank you very much for the question. Just to give some context here, my Gookum and Mushima, I would call them, my grandparents are originally from Northern Quebec, the Cree Nation, the Innu. So very familiar with what's happening up there. Certainly, what's happening in those communities with respects to incarceration is occurring in our communities as well. When you look at when I mentioned earlier, only enforcing criminal code in our communities, in NAN communities, in NAPS police communities, we are charging people under criminal code because that is the only law in many of our communities. So what are we doing? We're just exacerbating the problem by putting people into jail. Indigenous culture has been here for a number of years, thousands of years. We were a functioning society. We had laws, we had traditions, we had values, we had customs. And we need to get back to that because the system that is in place right now, the colonial system that we are using for law and order, is not working. So that's why when we look at the First Nation policing program, we need to be creative as to how we're going to look at protecting Indigenous people, their culture, their traditions, and their values and their customs. We have to look at meeting those needs because the current system is not working. And until we can look at alternative measures and get, appropriate measures for Indigenous people, we are always going to see overrepresentation of Indigenous people in our correction system. And not only our adults, but for our youth. It's still going to happen. It's still going to happen until we can look at providing a system that fits the Indigenous peoples across Canada. And as I mentioned earlier, there are a lot of communities that are implementing their own systems. Is it working? I couldn't tell you. We'd have to find out from those communities if it is or not. But I can't speak to any alternative measures that are happening other than alternative measures that are being at the criminal court, like criminal cases are being diverted, but there's still a criminal case. So we're putting people are getting criminal records for something that could be diverted. But yet, because that's the only system in place, many people are ending up with criminal records, and that's going to hinder them in their own development. If they want to leave their communities to further themselves, that is going to be a hindrance on them. Yes, we have pardon process, but we're still going to be creating people with criminal records.
2 minutes.
2 minutes.
Je voulais vous demander aussi.
I also wanted to ask you, you have a large organization. Have you had any recruiting difficulties for your police during the pandemic?
Fortunately, we have had to be creative in how we recruit. We have gone into other parts of Canada. We've gone into Manitoba to do a lot of recruiting. We have, prior to COVID, our human resources department always traveled to these colleges and universities to attract people, and they have remembered Anishinaabe Police because we are a large service. We offer a very unique schedule of going in for 2 weeks and coming out for 2 weeks. So we offer a good quality of work and home life, which is attractive to people. And we offer competitive salaries that are comparable to the OPP and benefits as well. So we do get people that come to us. However, because we are only a program, we are a revolving door. We get officers for a short period of time, and then they go on to larger police services with sustained funding. So, for example, my badge number is 11059, and we are now approaching, our badge numbers are in the 1700s. And that's been in 24 years since I've been here with NAPS.
Thanks, Chief. Thanks, Madam Bérubé. And Ms. Blaney, 6 minutes.
Well, I want to thank everyone for the testimony today. If I could come to you first, Mr. Falconer, thank you for what you've shared today. I think it's incredibly important. But I'm just trying to clarify. I think you said that there's a tripartite agreement. I'm just wondering if that's the case. Can you tell us what the process was of negotiating that, how long it took, and who was involved? I can't help but I'm going to come back to you, Chief Morrison. I'm just feeling hit by that reality, and I heard it earlier today about having a service if you are non-Indigenous and having a program if you are an Indigenous. That is just resonating in my brain. But if I can start with you, and then I'll come back to you, Chief Morrison.
Yeah. So the funding agreements that operate, and they operate under this umbrella of the FNPP. Keeping in mind, it's a program that was initiated pursuant to that policy I referred to in the 90s. So in order to administer that policy, each First Nation either does it as in the 9 standalones, they call them standalones, they're pure Indigenous police services in Ontario, there's 9, or does it through a shared arrangement, could be with the OPP in Ontario, or it could be with the RCMP elsewhere in the country. I do want to emphasize, and I don't mean to do a lecture, thank you for the question, MP Blaney, but I want to emphasize the Ontario case is special. It's special because we successfully, over a period of years, negotiated amendments to the Police Services Act that are about to come into force in January. And they permit the exercise of a legislative option by First Nations to become a legislated police service in Ontario. This is very important because it does away with the discussions about, quote, being an essential service and all that stuff. It doesn't act, in Ontario, a First Nation can apply and, if constituted, actually become just like other police services. So that's important. But getting back to MP Blaney's question, really, it's been consistent with all other vestiges of colonialism, which is, whereas for the rest of Canada, right, health is legislatively protected, whereas for the rest of Canada, education is legislatively protected. When it comes to First Nations, right, when it comes to Indigenous people across the country, of course, these are all done by programs. So policing was no exception. They show up, and the history has been they show up with a check to Indigenous people, and they say, this is your allotment under the funding agreement for this round. And that was historically called a negotiation. It was nonsense. They simply said, this is what's there, take it or leave it. And so Indigenous services struggled along. Along came, frankly, Grand Chief Yesno and then Grand Chief Fiddler of Anishinaabe Nation, along with Chief Terry Armstrong, the predecessor for Roland Morrison, and then Chief Morrison. And they said, you know what, to Ontario and Canada, we're not doing this anymore. If you don't, one, give us a process for creating a legislated service, then that's that option I talked about. And two, sign these terms of reference that will actually determine how we negotiate. In good faith, we're not doing it anymore. We're going to give you back the vehicle that has no brakes and you drive it. And because of what Chief Morrison does, which is police, so many remote communities, no surprise, they ran the numbers and found out it would cost them $1 zillion to police these communities. And so all of a sudden, NAN and NAPS enjoyed a leverage and used it in the negotiations. And so now funding agreement negotiations for NAPS, I am told, and I've been a negotiator for them with them for 2 or 3 rounds now, they look different than they used to. But what I need to communicate to everybody is that is not the case for the smaller services. That is not the case for the smaller Indigenous communities. They remain complete hostages to this totally keep First Nations down approach. I'm sorry to sound shrill, but it is important to appreciate that the people that suffer more today are these services that don't have the leverage, that continue to believe they're not allowed to have legal advice, right? That continue to engage in this tripartite process, which is not a negotiation. Here's your check. This is what you get, and they leave. So I hope that answers your question.
It does answer my question, and quite well, might I add. Chief Morrison, if I could just come to you, you talked about the services, victim services, emergency response, and so on, that you are not considered eligible expenses, which is interesting. You talked a little bit about how you deal with that by bringing the other police in, but I'm just wondering if you could talk a little bit about that, and what does that do in terms of your relationship building and trust building within the community? Because I know there's a history there that can be very painful, and I would assume that there's trust for your police force, but maybe not for other police forces.
That is correct. So we rely heavily on the OPP to supplement our service gap deliveries, and so they come in for major crimes, obviously homicide investigations. They have that capacity to do so. We look at providing emergency response and access to specialized units such as their tactical and emergency response unit, helicopters, IDENT units, forensics, so these are programs or services that we have to access from our policing partners because we don't have them. And services, like I said, the size of our service and comparable to Thunder Bay has all those services, whereas we don't. So that's why the terms and conditions is so restrictive in the First Nation policing program.
Okay. So I'm sorry, in view of the time, and I'm sorry to interrupt. These are quite important, but we're going to have time for 4 more questions, one from each of the parties before our allotted time. So Ms. Blaney, thank you. Mr. Viersen, you're up next. Please go ahead for 5 minutes.
Yeah, thank you, Mr. Chair. And I want to thank the witnesses for appearing at our committee again today. I appreciate your testimony. This 1996 document is really piqued my interest. And so we'll have to get our hands on that. I'm sure the clerk will be able to dig it up. If we can't do that, then I guess our individual offices will have to work on that as well. But unless you have a copy of it, Mr. Faulkner.
Yes, so the package, including the 1996 policy, has been sent to Mr. Clerk, and okay. We got an acknowledgement, I see in the email, that it's been received. So it's been sent to you today in the last hour and a half.
Well, I'm sure it'll be in my inbox shortly then. Appreciate that. One of the things that we've heard, and this is becoming, it's fascinating as we kind of move across the country. We started kind of out on the West Coast and now we've moved to Ontario, is that it's every jurisdiction, every province kind of thing is different. And this is proving to be, your testimony is proving that again today. One of the, and it seems to be interesting that you're well integrated with the provincial system in terms of prosecution. And so that's one of the areas, like where I'm from anyways, we have an Indigenous police service, and yet they're unable to get prosecution to happen because who's going to pay for that? And where is the jurisdiction, particularly when it comes to band council laws? That's the big. So I'm just wondering if both of you can just flesh that out a little bit. How does that work in your area? And are there like things kind of like nation or band tribunals or courts that you can appeal to, and or is that an option that you would suggest? I'll start with Mr. Faulkner and then Mr. Morrison.
Yeah, well, so first of all, I want to be clear. The initiative that Chief Morrison has led that has caught on beyond his territory, as I said, across this idea of these BCRs that combine assertions of inherent jurisdiction in the context of pandemic, but incorporate provincial laws around trespass and the emergency management laws that the Ontario provincial government ordered. These are unique, and there's still a struggle to even get them to catch on across INAN territory. So the integration we're talking about, and the Attorney General's agreement, and it's part of the materials, to prosecute these, it's brand new. So I wouldn't describe us as having been successful. What I would, historically, what's happened is pandemic has created that initiative. I think that incredibly important momentum to say this is crisis and we expect you to support us. But I also would observe this. The shock is that it's not just, the machinery of government. that makes the issue of recognizing Indigenous law challenging. Law firms. I mean, I can't tell you, Chief Morrison and I were chatting about this. Law firms are used to a toolbox, the Indian Act toolbox. So if it's not in the toolbox that they historically have used, they look at it with suspicion and don't want to help Indigenous people go forward. And I don't mean to sound like a competitive, nasty guy. I'm simply trying to tell you that the challenge comes from all quarters, because that Indian Act thinking, it's ingrained in all of us. And so I just say that I'll leave Chief Morrison to answer you as well. But I do say that this is new, and what we're pushing is pushing because of pandemic in part.
And just if I can sum that up in kind of just to sum up the thought, is around that if it doesn't say that you can't do it, that it doesn't, that's not allowing that you can't do it, kind of thing, right? So
that's
sometimes
true. That's true. And I should draw something to your attention, because it just came out in February this year. And to be honest, I think it speaks to what Chief Morrison said. And it's a quote from a judgment involving Iskatay Wazigagan, so Shoal Lake number 39 versus Winnipeg, over Winnipeg's sole source of drinking water is my client, Shoal Lake, since 1913. All right, 100 million gallons a day. This is what a judge said. One paragraph, I promise this won't take long. He recognized the role of Indigenous law. I think you'll be fascinated by this. It's paragraph 48 of a February judgment, just this February. The law that governs the relationship between Canada and Aboriginal peoples of Canada is what is now known as Aboriginal law. Indigenous law is not the same as Aboriginal law. Both before and after the arrival of European settlers, the Aboriginal peoples in North America had well-developed civilizations that had legal systems and legal customs. Those discrete legal systems are the source of Indigenous law. We'll make sure we get you that passage, but it's exactly what Chief Morrison was talking about before, and it reflects a Superior Court judge, Justice Perel, who's gone to the next level, and we all have to get there, right? Sorry.
I think that's just about time, Arnold.
All right, thank you, Mr. Chair.
Pam DeMoff, 5 minutes.
Thanks, Chair. Mr. Faulkner, it's nice to see you again. You appeared at Public Safety when we were studying racism in policing. And Chief Morrison, I just want to commend you and the INAN Police Service for the tremendous work that you do. You really are an example for the entire country. I know by your description of the challenges you have, you've made a case for validating why Minister Blair has been tasked with making policing an essential service in collaboration with Minister Miller. But you're right, it's not going to happen overnight. And I know you're also president of the Indigenous Police Chiefs of Ontario. And I'm wondering, this gets complicated between jurisdiction, between federal and provincial, right? The tripartite agreement, if I'm not mistaken, it's 52% federal funding, 48% provincial funding. So we'll just use Ontario as an example. We need to get Ontario at the table. So in your role as president of the police chiefs, are there conversations going on right now with the federal and provincial governments on how we can modernize these agreements?
Yes, we have ongoing discussions with the IPCO entity. We have ongoing discussions with both levels of government, and we're able to bring forward, items of concern and things that we feel that is necessary to address. Just as an example, right now with the modernization of policing here in the province of Ontario, Six Nation Police Service and Akwesasne are using a reporting system that is, I guess it's called the Interpol system. It is in order to look at what MAG is doing in terms of modernizing their court systems. Police services have to be on the records management system called Niche, because everything is flowing through Niche. However, Six Nations and Akwesasne will not be able to have this modernization for their service, because they're, like Julian had said earlier, here's your check. This is what you're getting for your agreement. And to modernize themselves, it's going to cost hundreds of thousands of dollars. So the province,
and there's no money for them to do it.
And exactly, their budgets are set. So
Yeah.
Here in the province of Ontario, I'm going to say that the provincial governments have been very, very cooperative in terms of making sure that we have access to resources, financial resources to make these changes. So the discussions with Ontario has been very positive. I would love to say
Some
that.
of that was because you were so adamant, though. I mean, you had people die in custody because you didn't have a proper place to put them, right? So, I mean, if you hadn't sort of drawn a line in the sand, and Mr. Faulkner described it earlier, you wouldn't be in the position you were. I mean, you basically said we're not going to have this happen to our citizens any longer, right?
Yes. So when you look at the death of Ricardo Wesley and Jamie Goodwin in Cache from 2006. If we didn't have that happen, if we didn't have that tragedy, what improvements would have occurred in the Anishinaabe Nation for policing?
What a horrible situation to be in, though, that two people had to die in order to make change. I know my colleague, Dr. Pawlowski, wants to ask a question because INAN is very near and dear to his heart. So, Marcus, I'm going to turn it over to you. Thank you, Chief Morrison, Mr. Faulkner.
Mr. Faulkner, Chief Morrison, you talked of the limitations in the services that Anishinaabe Police Force could do because of restrictions in the terms and conditions under First Nations policing program. But then you also mentioned that there's an upcoming amendment to, I guess, the Ontario Police Forces Act that would allow you to become a police force like other police forces. Does this then get rid of these limitations which are preventing you accessing the same level of services and as Thunder Bay Police? Is this the solution for you guys anyhow?
Just briefly, Chief, go ahead.
Yes, absolutely. There's adequacy standards under the legislation within the province of Ontario. So if we don't meet the standards, there is an avenue for us to make application to receive funding to bring us up to that standard. So that is why when you look at the legislation here in Ontario, which we've been told is going to be ready in January 2022, we are going to be making a submission to opt in under that legislation so we can get the resources to have a proper police service that delivers all the service requirements for the Anishinaabe Nation people because they deserve it.
Thank you. The Ontario Police Act calls for adequate and effective policing. Now we go to Madame Bérubé for 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Chair. Well, we're talking about budget. The government proposed $860 million over 5 years, and then $145 million afterwards. Are you satisfied with this budget? Is this going to resolve some of the financial problems you've been talking about?
When you have money set aside for First Nation policing, and you look at all the policing services across Canada, we have to compete with the respective Indigenous services for this money. And when you look at here in the province of Ontario and here in Northwestern Ontario, you got Lac-Seul Police Service. It is a 11 member police service. How, that the distribution of money is not going to be fair. So it should be fair. It should ensure that each police service has the same service delivery to ensure that they're meeting the needs of their people. As grateful as we are for the money, I think when we look at legislation, we should be able to have this money within our police service to deliver programs, and that should come through the legislation. But yet, when you look at what's being provided, we are still having to compete with each other in a divisive manner to access funding. It is no doubt, today I informed the INAN chiefs, we have a call every 2 weeks, and I told them about the particulars of this funding that was announced and that communities need to access programming as well to basically secure themselves, to have security programs for their communities to supplement and assist policing. It shouldn't be that way. But that's what communities have to do. They have peacekeepers because we don't have the adequate funding to employ a lot of officers in many of our communities. So this is a great budget. It's going to improve our communities. However, it needs to be sustainable. When you look at, it's only for 5 years. For 5 years, then what?
Thanks, Chief. And the final intervention question from Ms. Blaney. Go ahead.
Thank you, Chair. So my question to you, Chief Morrison, is you talked about the impacts on the reality of missing and murdered Indigenous women and girls because of the lack of funding. And I just can't help but tie that in with the limited resources that you have for victim services. And I'm just wondering if you could talk about that and the cultural responsiveness that you must have versus outside police force.
So when you look at our police service and you look at the Anishinaabe Nation territory, in our northwest area, we got in the Ojibwe culture. In our more centralized area, north of Thunder Bay and in between James Bay, we have the OG Cree culture. Then you got the Mushkego Cree on their east coast of James Bay. Different cultures, different values and traditions. So what we did with this Survivor Assistance Support Program is that we looked at getting people who are from our communities, who speak the languages, who can work with our victims. And what we did was that we advertised for social workers, because the trauma that they're already, facing, do they want to continue to speak to a police officer? So what we did was to be creative. We looked at employing social workers to work directly with our victims. And unfortunately, as beneficial as, we were happy to get the funding, that funding that we have is only for 1 year. So we have a program for 1 year to help our victims. And then we're going to have to reapply. It's sad. It's a sad state when that has to happen, especially when you look at the recommendations coming out of the inquiry and the commitment to ensure that there is service delivery to meet the needs, but yet for a police service servicing 34 communities, we got funding for 3 people for a population of nearly 40,000 people. It's not hitting the mark. It's way off.
And after a year, it's not going to be fixed, I would assume.
Oh, we'll have to leave it at that.
Thank you so much. Thank you.
Thanks very much. Thank you, everybody. And that time is our enemy. It's such a fascinating and beyond that, though, important conversation. All of the material that you spoke about will be brought into our testimony, and so you can be assured of that. I'm sorry to say that we have to suspend briefly. I'm going to ask everyone to leave in the meeting and come right back again in camera. This meeting is temporarily suspended.